factual matrix in order for my lord to make a rational, reasonable decision, and one which is not arbitrary. So, as things stand at the moment, we are unable as a defense counsel to be able to indicate to my lord why that is significant, because we don't have this C-section. Now, this C-section could only have started in March 2024. So, insofar as dealing with the admissibility of the hearsay evidence of General Palomisa, that the searching for the corroborating facts for his evidence to make it admissible will be found, well, it's not in the A section because they haven't disclosed those facts. It's not in the
Where is this affidavit?
It's in the police docket.
A section?
Yes.
Yes.
Now, so in order for us to place my lord in a position to assess the corroborating factors for hearsay evidence, which is normally inadmissible, it's not in the A section. We know it's not in the B section, and it must be in the C section. And the C section must have an explanation in it as to why a statement was taken before the police had a mandate to do the investigation in the first place. Now, that theme is repeated quite often. And remember, the background is we want the DACWA docket as well. May I just break off and deal with that for a moment?
Are you dealing with D now?
Yes.
You are done with C section?
No. Okay, I'll finish with the C
section. Yeah, but why are you mixing the two?
Why am I?
Mixing the two.
I'm not going to. I've changed my mind.
Yes.
I'll take my lord's guidance. If one looks at 37.2, now one is dealing with Mapisa-Nqakula, who is the 204 witness in this matter.
Yes.
Now, it is our case that the 204 certificate that she was granted made it impossible for her to be indemnified in this trial because there was a failure of its drafting. But now it becomes additional.
Let me understand your submission. Are you saying she was given a Section 204 certificate?
Yes.
In which matter?
In this matter.
The trial hasn't yet commenced.
Well, her affidavit starts with a certificate in terms of...
But what certificate is that?
No, I see my lord's problem. My lord indemnifies the witness, I understand that.
No, but you only, in terms of the law, you only indemnify the witness after testifying.
Indeed.
And if you are satisfied with the evidence, whether was he telling the truth or not, then it's when you can indemnify the witness.
Yes, but the state promises the witness that if she testifies to their satisfaction, notice to their
Yeah, but that's not their space.
I agree, my lord.
That's not their space. They can promise whatever I have in earth. But if I'm not satisfied, as a trial judge, I cannot indemnify that witness.
I'm so pleased my lord raised that, because the surrounding circumstances of the 204 certificate, which in our opinion, the promises made to her were inaccurate, which makes the freeness and the voluntariness of her making that statement suspect. Now, we only have the certificate, in the purported certificate in the docket, and the Lord has said, well, it shouldn't be there, I'm not going to take that point.
Yes.
But the circumstances of her becoming a 204 witness will be in the C section of the docket. It's nowhere else we can't find it. Now, it's also additionally significant that this affidavit by this 204 witness was taken 7 months before this docket was opened. Now, the explanation for that we don't have yet. And we do know from the facts in the urgent applications and the like that her matter was withdrawn, and 2 days later my client was arrested, and this matter was enrolled against my client. So I raised that suspicion. Now I'm raising the suspicion with a great deal of care. My Lord is not here to decide whether the 204 certificate, which my Lord said shouldn't be there, but is there, was appropriately, whether that certificate or that undertaking was appropriately given to the 204. We're not trying to ask you to find that she should be indemnified. What we are asking you for is the surrounding information relating to her being given that promise. In other words, was her statement